the division, in line with the judiciary transformation agenda, currently has 6 judges. We received one yesterday, and we have one judge who is circuiting. That's Justice Alice Komuhangi. The other judges in the court are Justice John Ketirima, who is the head of division. We have Justice Ketra Katunguka Kitarisibwa, who is the deputy head. We have Justice Elizabeth Kibula Kabanda. We have Justice Jean Wakakoko. We have Justice Celia Nagawa. And yesterday we were added Justice Dr. Christine Akelo Echokit, and we were excited about the addition to the court. The court, in line with the judiciary transformation agenda, has been able to work with the processes, both within the law as well as practices from the stakeholders, in a bid to improve service delivery to the citizens of Uganda. Currently, the court operates within Kampala and Wakiso districts, and the court usually picks up processes from the Office of the Administrator General. For the relevance of today's theme, usually when a person passes on, there's a requirement that they have to go to the Office of the Administrator General, who I will refer to as AG, to be able to hold a meeting and whether it be vetted in a view to identifying the persons who will be put on the certificate of no objection. So after the meetings with the AG's office, usually they are sent to go and hold a family meeting with the cow, either the cow or the town clerk, and then be able to report back. So once they have obtained the CONO, certificate of no objection, from the Office of the Administrator General, they can then be able to file a petition. And that petition will start with the notice, which will be published in a newspaper of wide circulation. And usually the court insists that that newspaper should be the one which is relevant within the area where the estate is located. So other requirements at that point will include the death certificate. We require the CONO issued by the Office of the Administrator General. And in terms of the processes, we've been working with the Office of the AG, and at that point we agreed that CONO should be expiring within 1 year. And I know that they may be moving to come down to about 6 months. Because the idea is that when you go to the Office of the AG, you're going to pick the CONO and then walk to the court. So we believe that even if you actually walked, within 6 months, you'll be able to walk from Georgian House to Family Division in Makinde. So we think that the 1 year for now, and maybe in the future, the 6 months, should be sufficient for the proposed administrators to be able to move from the Office of the AG and come to court to be able to file a petition. The court will require the photographs of the deceased, as well as the photographs of the persons listed in the CONO, who are supposed to be the administrators, to be published in color. The court insists that they should be in color for ease of identification, because we have had challenges with the processes in terms of people coming to misrepresent the estate of the deceased. So currently the court insists on a colored photograph, which should be big enough to enable the identification process go on in line with the law. The digitization process in line with the transformation plan. And through these processes, the court has been able to support this process in terms of video link in these processes. So if some people are out of the country, the court usually allows for identifications via link, via Zoom, as well as other applications. Usually where where a widow is involved, usually the court has usually a soft spot that should be preferable that a widow or the widower should be able to appear before court and either consent to the grant to the people named in the corner, or at least be added as the administrator. So where they consent, the court will be able to comfortably work with the persons who have been listed in the corner by the Office of the Administrator General. The petition should be accompanied by, among other things, the declaration of the petitioners. We have a certified copy of the minutes of the meeting they held at the Office of the AG, as well as the minutes of the meeting with the Office of the Town Clerk or at the Office of the COW, depending on the location of the petitioners and the estate. Other requirements at that point will be the bond form, the estate. The estimated value of the estate must be mentioned in the petition, so that is easier to deal with the process as the parties progress with the process of identification. Regarding petition, the court usually works with the death certificate, the will of the deceased. Usually the will must be properly witnessed, and the court will want the witnesses, if they are alive, to appear in court for identification and be able to verify that will. Where one of the parties, for example, or the witnesses has been passed on, the court requires a declaration or an affidavit to that effect be filed in court. Of course, in terms of probate now, there's also a requirement that we need these widows and widowers to be vetted by the Office of the AG to be able to cut down on some of the fraud in the process of grant of letters of administration, as well as those of probate. This still has to be advertised in a newspaper of wide circulation within the area where the estate is located. In Central, then we prefer maybe Bukede or Daily Monitor or the New Vision newspaper, so that the public is notified about your interest to apply for letters of administration for the estate of the deceased, so that if there are any issues regarding the estate, somebody can be able to protect their interests in terms of lodging a caveat on the petition. Certified copies of the minutes where they have had a meeting with the AG. We want those minutes. And then in terms of the caveat, following the amendment of the Succession Act, amendment of the law last year, there's a requirement that once you file a caveat, you must, within 6 months, file a suit in court to give your reasons as to why you lodged the caveat, and that the court should be able to hear you out and give a decision to that effect, or regarding your issues or challenges to the petition. Secondly, the petitioner is required under the law to file a suit. If the caveat does not file, then the petitioner should file the suit within 6 months. So if both of them do not file the suit within the 6 months, then the law provides that both the caveat and the petition shall lapse. And usually when those lapse, the court will dismiss the application. So the party will have to come back and reinstate that petition in court. After reinstatement, the caveat cannot file a new caveat because he had the opportunity to file one, he didn't explain himself, so the court will have that dismissed and proceed with the process of identification to grant letters of administration or probate to the petitioners. Chief guest, in terms of identification processes, the court requires that we have in line the identification form, need a recommendation from the local area chairperson or the LC1, just to be sure that the person is within the country and is a citizen of this country. We require the petitioners to appear the beneficiaries who are around should also appear in court. We require the national ID original. Of course, we've had challenges in this area. I'll come to this later. The registrar has to verify the original documents brought by the petitioner. And then the court explains the roles and duties of the administrators to the persons who are appearing before the registrar. And then the registrar will sign off the documents and forward the file to the judge for consideration. In terms of letters of probate, Chief Guest, the witnesses are required to appear as well to be able to verify the will in issue where there's a will. Because most times we have places where the wills are challenged, so that usually moves to the other side of letters of administration. The law also allows the chief registrar or the deputy registrars of the High Court to be custodians of wills. So, Mr. Vice President, if the wills are made by council, they are liberty to drop, they deposit them at the High Court. The chief registrar can ably take custody of those wills and be able to release them when they are needed. Our chief guest, the law requires that once letters of administration are granted, the administrators must within 6 months file an inventory. The properties of the deceased, the beneficiaries, as well as other requirements in line with the law. Usually when they are not able to file the inventory within 6 months, the law requires that they should be able to file an application in court for leave of court to grant them time to file the inventory outside the 6 months. And then in a period of 1 year, they're supposed to file a final account in court. And of course, the grant or letters of administration should be able to expire within a period of 2 years, within the new amendment to the Act. Where the letters have expired, then it means the petitioners have to start the process in terms of going back to the office of the AG, getting letters of recommendation, advertising, and then come back to court to be considered for grant of letters of administration. The court also insists and speaks to the beneficiaries whenever they appear in court for this grant is that they should be able to be keen on the process of the management of the estate of the deceased in terms of receiving their shares, as well as keeping a watchful eye on how the estate of the deceased is being managed by the administrators who have been given letters of administration or probate by the court, as well as collectively ensure compliance with the law in terms of filing the inventory within time, as well as filing the final account. In terms of challenge, where somebody has an issue with a grant which has been given to an administrator or an executor, then they should be able to challenge in court in terms of filing a suit and be able to bring evidence as to why you think the administrator who holds the letters or the probate should be removed from that position, and the letters be given to a new person who the family, having sat in a meeting again with the office of the Administrator General, should be able to pick new people who are put on the corner to be able to facilitate that process for grant of letters of administration.